Good morning, everybody, and welcome to this edition of Macro Pro and Friends. So today I'm joined by James Rossi, a brilliant attorney here in California. James, how are you doing?
I'm doing great. How are you, Diane?
I am outstanding. We are like 2 years into this pandemic, and I think we're finally starting to see the light of day, and things are starting to become more normal. So tell me, what do you think has happened in the workers' comp system that's going to stay?
Well, I can say for me personally, I think the remote's going to stay. I think it's been really, really great. I've got all my paralegals except for one, actually two that are working at home. I've got all my attorneys except for one working at home, and it's overwhelmingly popular. Everybody loves it. They love just having to walk downstairs and they're at work already. They don't have to travel to court for these, an MSC or status conference. A status conference, for example, we could have some minor issue and an applicant attorney doesn't come see us till 11:30 in the morning, and we've been waiting the whole time, and then it goes off, and then we got to drive back, and now it turns into 30 minutes versus like 4.5 hours. So that's really,
Wow.
really wonderful. I think it's great for morale. I hope it stays, but I think it's going to stay.
Well, it sounds like it's good for the client's checkbook too, right?
Oh, it's great for the client's checkbook. Absolutely.
So I'm wondering, for those of you watching this webinar right now, maybe you want to key in there and put in the comment box whether or not you love working at home or if you prefer to go back to the office. I know there's 50-50, right? A lot of people like to be in the office. I think hybrid is very nice. So what is the one thing that you think might stay that you wouldn't like to see in the workers' comp system?
You mean from COVID or?
Yeah, from the pandemic, things that have changed, you know? Is there anything that we've done since then that you're just not too keen on?
I mean, not really. It's more just been a mode of survival, get through all this, get everybody healthy and make sure that, you can move on with life beyond this. That's pretty
Yeah.
much where I am. I mean, to me, it's just going to get better, I think.
Yeah, I think so too. I know the DIR, for example, is having struggles. States got hiring freezes, etc., which is slowing things down. In fact, one of the things I wanted to bring up today is a little bit on our new regulations that are coming up.
Yeah,
So
are those going to be hit? Are those going to go forward on April 1st, you think?
they're not going to go out on April 1st. I mentioned that there was a hiring freeze, and what's happened with the DIR is things have slowed down because they haven't been able to hire. There's a 6-step process before a regulation gets updated or implemented. And the first one, of course, is a public hearing. And the second one is to do the translations on the records. And as I understand it, the records were not yet translated from the last hearing. I know that they were working really diligently to get that done so they can get into the next phase. So we're not looking at April 1st when it comes to regs. We're probably looking at June, maybe July 1. Look for a notice from the DIR, and I'll also probably post something on LinkedIn, etc. But there are a few things I do want to make everybody aware of when the regs do hit. First of all, we're looking at changing from $180 to $230. They have not had a pay increase in over 7 years, so it's basically going to equal that of what COLA was going to be. However, the thing that's really big and really important is the DIR included a 25% penalty for any invoice not paid within 30 days. So this is gigantic, and you should know that any amount that it was not paid, let's say you made a small payment on it or a partial payment on it, but you didn't pay everything. If it went to lien trial and they found out that that should have been paid in whole, you're going to be penalized on the entire amount, not just the part that wasn't paid. And that's the way I understand it. So we want to make sure that we're making those payments diligently. But there are a lot of wins for the defense that are really, really exciting and that we worked really hard for. Our clients, for example, getting an additional set. A lot of times doctors don't want paper. They want, they don't want an electronic copy, they want paper. And here we're going to be able to provide it to them. In addition to that, we're going to be able to provide any additional services that you deem necessary. In the past, process serving would be kicked out by bill review, or medical summaries were kicked out by bill review. Now there are special codes included. So it's going to be a really good thing.
That sounds great.
Excellent. Okay, so before we get started the webinar, I'm just going to give a little bit of housekeeping here. Today's presentation is one CEU in California. So you will get that certificate in 1 hour. If you have any questions for our experts today, then put them into the comment box and we will be happy to ask those questions of our experts for you. There are handouts on today's webinar and it's going to be a great topic. So you want to make sure that you do download those, as well as paper on the regs. And then James has got a surprise for you in there as well. So he'll tell you about that. And you're going to be talking about work comp defenses, and that's a big topic today.
Yes, it is. That it is.
Hi, and can you tell us who your guest speaker is going to be?
My guest speaker is Ali Vasai. He's the vice president of Rossi Law Group, and he's one hell of an amazing guy, one of the best attorneys out there, and I love him. And there he is. Mr. Vasai, how are you?
Good morning. How's everybody doing?
Oh, not bad, not bad. Great to have you. So this is going to be our topic, defenses of workers' compensation. You got James and Ali there. And Diane had mentioned that there was a little bit of a surprise. Some of you guys may already have this, but I find it to be fantastic. This is one of the attachments is this cheat sheet. And you can see it's got all kinds of defenses. It's not every defense. There are defenses that we're not going to address, but these are defenses that come up quite frequently. And it's something that you can just have at your desk. If somebody wants a laminated copy, they just need to let us know and we'll send it laminated. I personally keep it on my desk. I use it because it always keeps me fresh on the defenses. They don't slip through the cracks. And then I also use it as a coaster so that I can put my coffee on it without ruining my desk. So it's a fantastic tool, and you'll see on the left column, it has the defenses 3600A 4 through 10, and those are the statutory defenses. And then you go to the middle section and it's got other defenses which are not necessarily statutory defenses. They may be case law. Then we've got some psych defenses, and then we've got statute of limitations. So it's pretty comprehensive, and it's just a great tool. And if I was an adjuster trying to issue my denials, I'd be using this because it's wonderful. So that's the surprise, and now we're going to start talking about all of this. And to do that, I will go to the next slide. So the first thing we're going to do is talk about the statutory defenses, which is LC 3600A 4 through 10. And you can see a list of those defenses, and Ali's going to be hitting all of these, and we'll discuss them as well as we go through it. But for now, I'm going to kick it off with
Ali, are you?
LC 3600A4, which is the intoxication defense. Ali, take it away.
All right, so intoxication defense requires that the employer prove 3 things. So they have to show that the applicant either drank alcohol or consumed unlawfully a controlled substance. There's a list of the controlled substances in the Health and Safety Code. Something to consider is that if the applicant has a prescription for the controlled substance, it's not unlawful. So if an injured worker has taken a number of Vicodin pills, for example, and he had or she had a prescription for those medications, that would not be considered an unlawful use of a controlled substance. There's actually a case where an applicant accidentally overdosed on his medication, and the court said that this was not an unlawful use of the prescription because it was an accidental overdose. Now, in addition to that prong, you have to show that the applicant was actually intoxicated. This comes into play more so like if you have an applicant that's an alcoholic, for example, whereas you or I may have 4 cocktails and we would be hammered, and an applicant that's an alcoholic could have 8 drinks and not be intoxicated in the same manner that's required. So you have to prove that the observer would see the applicant being impaired, intoxicated, or under the influence at the time of injury. So an employer should be told that whenever they think that there might be a defensive intoxication, they should have a blood test done as close in time as possible to the incident. This is not alone going to be what you need. You also need a witness testimony to say that the applicant's behavior was erratic or the witness saw the applicant consume the items. Next, you have to show that the intoxication caused the injury. So there's two ways you could do that. One is that the court could say that there was no reasonable person could reach any conclusion other than the fact that the intoxication was the cause of the injury, or you can have an expert testify that the effect of the intoxication was the cause of the injury. Now, if the employer tolerated or encouraged the applicant's intoxication, the employer will be stopped from raising this defense. So in other words, if the employer knew that the applicant was consuming alcohol on the date of the accident, or if the employer furnished the alcohol to the applicant or the employer participated, these are all examples where the employer would not be able to raise the defense. James, do you have anything to add on this one?
Yeah, I had a case, what you said actually brought it up. It was a case I had a long time ago, actually. But a guy, he went to lunch, he was at a construction site, and he had a 24-ounce beer in the car with a coworker. Right after having it, he got into the basket that lifts you up to, I think this was the 3rd floor in this instance. And so he tried to go from the basket to the roof in a silly way. It just made 0 sense why he would do that. It was very risky. He ended up falling and dying. He was loaded up with liquids. They tried to save him before they could do any kind of testing to find out, BAC levels. And so, but he did, when they finally did the test, he did have some alcohol in his blood, low amount, below the legal limit, well below that. And so the question became, was he intoxicated at the time? And so I took the deposition of the wife and I asked her, what does he normally, does he drink every night? Because what you said earlier, where they can say, well, 2 beers does nothing to me. I drink 10 beers a day. And so I figured she would think it's better to say, you can test credibility when you ask these types of questions, but I did it very early in the case. And she said that he didn't ever drink. So not ever drinking, 24-ounce beer, had a witness, took his deposition. He said he was with him. He drank the 24-ounce beer, went to the QME. The QME said that he, even though there wasn't a lot of a high BAC level, the fact that with all those liquids that he had put in him, since those were all put in him, he shouldn't have had anything at all, really. So it was consistent with having a 24-ounce. So then later, the applicant attorney tries to argue, well, he's a heavy drinker, and so therefore, one beer, 24-ounce beer, wouldn't have done anything to him. And so then I rightly pointed him to the testimony of the wife that was taken in the first 2 months, and where she said he never drank, and that argument went down, and obviously the defense went well. But that's something that you got to set up from the get-go. Make sure that they're not able to say, well, his tolerance is extremely high. But I found it to be a very interesting case, and it hits on the head what you just mentioned.
Can you go? Perfect. Thank you. All right. So the next defense that we're going to talk about is a self-inflicted injury. So here, the employer has to show that the applicant intentionally injured themselves. And this is different than a spur of the moment or spontaneous situation where if you have an applicant who's upset and angry and he punches a wall, this is not the same intent as somebody who had pre-decided that they were going to injure themselves. So in addition to that, you need to show that the injury was caused by the applicant's employment. So an interesting case was that an applicant sustained a burn, and the burn was self-inflicted. And they raised the self-inflicted injury defense, and the court didn't allow it. And the reason for this is that the applicant had sustained an orthopedic injury on an industrial basis. As a result of the orthopedic injury, he or she was feeling depressed. And it was because of the depression that the applicant burned himself. So because the burn was as a result of the depression that was as a result of the orthopedic industrial injury, the court did not allow the defense. So this is an example of that. This one's, it doesn't really come up that often. I've never seen it come up, but just something to keep in the back of your mind.
Yeah, I agree. It's an unusual defense.
The next one is quite similar. If the applicant acted with the specific intent to attempt suicide and the action was not an irresistible impulse, then the injury would be barred as a suicide. So how you'd prove this is you'd need witness testimony or an admission made to the doctor. So he needed to tell the doctor, like, oh yeah, you know, I attempted to commit suicide. There was a case where the board drew an inference that the applicant attempted to commit suicide because they had evidence that the applicant was depressed, self-destructive, financially unstable, and the applicant was looking at insurance papers before the injury. So there are ways of having the court draw an inference, but there were a number of factors there that the court looked at.
Yeah, I've actually seen the suicide defense come in a few times. I had the one most notable to me is there was a farm laborer who had to leave work early. His wife also worked there, and he went to get a newborn baby that they had, or maybe it was 6 months or so. And there was evidence that this guy was really unhappy about having the baby. He was having a lot of family issues, according to some witnesses.
Oh, are you talking about the train one?
Yeah, that's where I'm going. Yeah, so the he goes to pick up the baby, comes back to the field, and is waiting for the wife to finish her shift. She has, like, you know, half an hour left, something like that. And all of a sudden a train's coming, and the train has video on the track the entire time. And so you can see his car from a far distance. As the train starts to get closer, you watch him back the car up to where the baby is in the back seat. The baby is literally on the tracks, and he stops. And I watched this video probably 100 times, and at no time did I ever see anything that led me to believe that he was trying to move the vehicle out off the tracks, that he was nervous. He just stared at it. Maybe it was a deer in headlights, but he just stared at it. And when you looked at it all, it looked like evidence, strong evidence of suicide, because people don't back up on the tracks when trains are coming and just sit there without any kind of emotion. And so we raised the defense successfully, and so it was quite a crazy case.
Yeah, I remember that. I remember
yeah.
setting footage.
Yeah, that was nuts.
Yeah.
Did you actually watch the footage?
I did.
Probably.
I did watch it. One. Yeah, it was bad.
I was asking for opinions from people, so that makes sense. All right, so next up, you're at the initial physical aggressor. Go ahead.
Yeah. Okay, so this defense requires that the applicant be the person that made an overt act, which is more than just an argument or an obscenity or an insult. So the courts have said, like, clenching your fist and like approaching somebody would be an overt act. It doesn't require a battery. And the overt act has to be as a result of animosity between another person and the applicant regarding an issue related to the employment. So it can't be that they're having a personal dispute regarding a romantic involvement. It has to be about the employment, and it has to take place in the work environment, and it cannot be something that benefits the employer. So it can't be a fight over a business dealing that benefits the employer. For example, there was a case where there was a altercation between a foreman and another employee, and this employee that tried to stop the fight ended up getting injured. And he was arguably the person that made the first act, but because he was trying to benefit the employer, it didn't apply. So the overt act has to be such that a reasonable person would perceive it to be dangerous or a threat of bodily harm. So if you have all of those things in play, then you could raise this initial physical aggressor.
I see this defense a lot. Do you?
Never, not once.
You've never seen this defense?
I've never had this exact defense where they've gotten into an altercation at work regarding a work issue. That's the big issue, is that it has to be regarding a work issue. Most of the time when people get into arguments at work, it's not regarding a work issue, it's about something personal, and then it doesn't apply.
Well, my experience is I've seen a lot of fights, attacks, things of that nature over the years, and it's always difficult to determine who started it, who said the first thing that created it, and so we have to go to witnesses. We'll look for videotape of the incident. I've had actually cases where it was caught on video. It was, you know, like in a break room, or it was in just in a place where there happens to be a camera at the facility. And you know, to me, I find it to be a pretty good defense. It's a hard defense because, like I said, you got to be able to point out who started it,
Right.
and was it a conduct sufficient enough to justify actually physically hurting somebody or attacking somebody. So, and I had one where the other person was killed, stabbed. Actually, I've had a few similar like that where employees were killed in the fields. And so it's a defense that I find come up quite often, and surprised that our experience is so different.
Right. Well, you know, it just depends on what case you get.
Yeah, and what kind of cases, you know, because every industry is different.
Yeah. Okay. The next one is an injury resulting from criminal activity. So if the applicant committed a felony or a crime or misdemeanor that's punishable by imprisonment and was convicted of the crime, that's an important thing. If there was no conviction, it doesn't apply. And the criminal conduct without the conviction will only bar compensation if it constitutes a complete deviation from the scope of employment. So if it's not a complete deviation, you need the conviction, and the crime itself has to be a contributing factor without which the injury would not have occurred. So, and the criminal conduct cannot be done in the course of the applicant's work. So an example was, there was a delivery driver who was attempting to evade the police in a high-speed chase after running a red light. This guy was awarded compensation because he was attempting to make a delivery at the time of the incident. So it was a situation where the criminal conduct was done in the course of the applicant's work. Another famous case was in connection with the Rodney King beating, where there was a compensable psych and internal injury sustained by the police officer that did the beating. And even though the beating of Rodney King was not in the course and scope of the applicant's employment, and it was unauthorized and perhaps even criminal, it was still allowed because it was within his job duties. So that was just one that is very interesting, that would be considered to be within the course of the work, even though it's criminal. Now, if the employer tolerates or encourages the criminal activity, estoppel applies and the defense does not. So an example would be if an employer encouraged the applicant to drink and drive under the influence, that would be a scenario where you wouldn't be able to raise the defense.
This is not a common defense.
Yes, not a common defense.
But it is listed in the labor code.
Yes.
3600 A8, so it's an affirmative defense. And they felt it was important enough to take the time to actually codify it. So it's something you definitely need to know when you're reviewing a case. You get a new case, you got to just make sure that these issues aren't there. And And the goal, as an adjuster, as an attorney, is to spot the issues, to spot the defenses early, because you want to avoid that presumption of compensability. You want to make sure you do everything timely, and if you don't ask the right questions, you don't get the information early on, you may lose the defense. So even though this is not a likely one, you still got to make sure you evaluate it.
The next defense is if the applicant was injured during an off-duty, recreational, social, or athletic activity. So the participation needs to be voluntary. I'll talk about that a little bit later. And the activity has to be concerning one or more of the employees interacting off the clock. It could be on or off site. And the activity did not constitute part of the applicant's work-related duties. In order to prove that, there's a two-pronged test where you have to show, did the applicant subjectively believe that his or her participation was expected by the employer? So the employee can establish the factual issue of subjective belief by testifying that he or she believed that the participation was expected. If the applicant doesn't remember or is deceased, other witnesses can provide evidence as to the applicant's subjective belief. The second prong of the test is whether it was reasonable for the applicant to have believed that. So whether the belief was objectively reasonable, express or implied pressure from the employer that he or she was required to participate in the off-duty activity. So it could be implied pressure. So an example would be, there was a case where an employer had sponsored an athletic activity. So they had paid for the activity and they had provided a basketball court. And this alone was not sufficient because they don't want to create a scenario where employers don't want to, do nice things for their employees. It's that there needs to be an underlying feeling of pressure for the employee to feel like they have to do it. So there was another case where a young lady felt pressured to participate in like a female basketball league. And the reason why this one applied was because there was like league requirements that there be a certain number of women participating in the league in order for it to be valid. And the employer was pressuring all the women to participate because they wanted to meet the requirement. So that was an example of a case where there was implied or even express pressure from the employer. One of the things they recommend is that if there is ever an activity such as this, that we advise the employers to post a notice advising the employees that it may not be responsible for an injury due to the employee's voluntary participation in the off-duty activity. And if the employer fails to post the notice, this doesn't waive the defense. It just makes any action by the employer that tends to encourage the participation even more coercive without the notice having been posted. There are certain employees where they work in the same place that they go to lunch, for example. Like if you have a person that works at the mall, and this person was working at the mall and she was injured while shopping with her roommates at her place of employment, but it was during an uncompensated lunch break. So this was not something that was benefiting the employer. It wasn't during her work hours. So this would not have been something that would have been something that the employer like coerced her to do or anything like that. There are other people whose job required them to be on call. So if you're on call and you have an injury, such as a detective who's working standby, and he sustained an injury in a softball game between his employer and another sheriff's office. So the combination of the fact that he was on standby and it was a sporting event that was between the employer and another sheriff's office made it seem like it was something that he should have participated in. So it's a case-by-case basis. You have to look at the facts and see what your witnesses are going to testify to see what you would be able to establish.
Yeah, and it comes up commonly with like Christmas parties and park activities where the offices will go to the park and play sports and things like that. And the question becomes, are they required to be there? Do they believe they needed to be there? And is it objectively reasonable? And so like, for our purposes, when it comes to the Christmas party as an example, nobody's required to be there. Is it possible someone subjectively believes they have to be? Yeah. Could it be objectively reasonable? I mean, it depends on other people. To me, being that I'm the one that sets the rule, I know they don't have to be there. So is it objectively reasonable? I don't know. It would have to be decided by a judge. Are you frozen?
It looks like he is frozen.
He sure is. So while he's fixing that, we'll go on to the post-termination injury defense. This is one of my all-time favorite defenses. It's become a lot harder in recent years because now these applicant attorneys have figured out a way to get around it by alleging a cumulative trauma instead of a specific. Back in the day, a specific was very easy because all I had to do was show that the date of injury is before the termination, the notice of termination, because it's a specific. A CT, they have the ability to say, well, I didn't know the date of injury. I didn't know about the injury being work related until I stopped working for the employer, and I found out from a doctor who said my cancer was caused by asbestos exposure while working for the employer, or my doctor said that my back problems were as a result of doing the lifting that I was doing at work every day, and I didn't know until after the fact. And they can do that and they can get around it because now the date of injury is not before the notice of termination. So the applicant attorneys these days are doing that, the cumulative trauma injury, date of injury in almost every case. I see it 9 out of 10, which it didn't used to be the case. It was usually a specific. And then it would be, if you get them to admit they didn't treat, which is usually the case, you get them to admit they didn't miss work. There's no medical records predating the termination notice. You were going to be in good shape. Didn't report it to the employer, no notice of any kind, you were going to be in good shape. But now they can say, well, I didn't know it was work related. So we have a strategy that we employ that's actually been, I would say, very successful on giving us a legitimate post-term defense against CTs, which I've actually been told by a judge once that you can't even have a defense, post-term defense on a CT because of the date of injury issue. And we went to trial, and once my cross-examination was done, he brought the attorneys into his chambers, and he said that he changed his mind, that he believes that the case is going to be defensible. He's non-compensable. And it's a strategy that's employed, that you basically show the date of injury is before the notice of termination, along with other facts showing the applicant knew all about the injury. He had the worst pain he ever had was while he was working at the job, that he knew it was work related at the time, things of that nature. And it gives you an argument that the post-term defense still applies. Now, one of the requirements is that the employee has to have the actual knowledge of the termination, obviously. He has to be told, or she has to be told, that they are going to be terminated. The employer must have actual knowledge of the injury. So if the applicant reported it to a supervisor or reported it to some high-level person and the employer is aware of it before giving notice of termination, then that's a way to get around it. Medical records is a big one. I see that one, and I find that to be the most reliable, because oftentimes the applicant will say, yeah, I reported the injury to Supervisor Joe, and now we've got Supervisor Joe saying that didn't happen, and we've got a credibility issue, and so now we have to do is gather as much evidence as we can showing that applicant doesn't have credibility. And by not having that credibility, you can't believe him over the employer, and so the employer is the one telling the truth that there was no injury reported. So it's it's a very interesting defense. It's a fun defense. It's an extremely common defense, and it has a lot of legs. So I see this defense coming into play. God, maybe 15-20% of our cases. There's just and they're always CTs these days. Almost never an ST, which is much easier. All right, so next we're going to talk about some additional defenses that are not necessarily they're not necessarily from a code section like LC 3600 A4 through 10. They're from case law, things of that nature. Some of them are actually code sections, just not the affirmative defenses under 3600 A4. The first is prejudicial failure to report within 30 days. I personally love this defense. This comes into play when you've got an applicant who didn't report it, and oftentimes even when there's a post-term, I'll allege this one too, because there's usually list every defense you got. Don't if it could possibly apply, you list it and you go for it. So the prejudicial failure to report defense comes into play when the employer says, we knew nothing about this case, we never terminated the applicant, so there's not a post-term defense, but we don't know where this injury came from. Yeah, the guy's been working fine, he's been doing his full duties, and now here we have this claim, and it's for an injury that was 6 months ago. So what we'll do is we will try and find prejudice. Prejudice is the key. If you don't have prejudice, it doesn't matter that it was reported late. It just doesn't matter. So the way you find prejudice, some of the examples that I use is when you had the injury, did you have swelling? Did you have bruising? Did you have redness? Did you have any visible injuries? Yes, I did. I had all those things. Okay, well, and did those visible injuries heal? Yes, those invisible injuries heal. How long did they take to heal? Within 30 days, they were fully healed. Well, that means you filed your claim 5 months thereafter. How can we possibly verify that there's an acute injury of swelling of, basically it's a new injury that's consistent with the day alleged that he was injured? And so that's prejudice, in my opinion. That's prejudice. And then I had another case that was a really big case, a nasty injury, an infection that the guy had, major infection, was hospitalized, ended up impacting his heart. It was a 100% case, and he was a mess. We found some records where he had evidence of an infection, similar infection, like a year before, and he claims that he got glass. He's a glass cutter. He got glass in his boot that caused a cut that he didn't report. He went home, he cleaned it out. He had a bloody sock allegedly, but none of this was reported for long after. And eventually, the infection got so bad that he was hospitalized, and it just turned into a big nightmare. And so we raised prejudicial failure to report because we had no way to verify that he actually cut himself with the glass as alleged, when alleged. And so the defense actually had a lot of legs. We ended up resolving the case, but the settlement definitely reflected the strong defense of prejudicial failure to report. So it's a tough defense. You don't see it very often, but in my opinion, it's a great defense, and I raise it a lot where appropriate. And the next one, Ali, is horseplay. Welcome back, buddy. I can't hear you. You got to turn on your mic.
Ollie, under the orange arrow, there's a little microphone just above the camera.
Yeah, and sorry about this. We're just not very good with webinar. Go to webinar. We don't know it very well. We do a lot of Zoom. But so horseplay and skylarking, this is indicated as a judicial doctrine. You're just looking for anything that shows people were horsing around it, and it led to the applicant's injury. Yep, there he is.
Okay, right.
So examples: a hotel busboy throwing hard rolls at each other, ranch trainees chasing each other around a bunkhouse, sparring. My favorite is the jumping off a third floor balcony into a swimming pool on a bet. These are the types of things that are going to be barred. And so you'll always want to look for how did the accident happen and see if there was any messing around. And if it was, you may have a defense. It's not very common defense though.
Something that I thought was interesting is that there's a couple of cases where the applicant wasn't found to be engaging in horseplay. One was the applicant had descended stairs by grabbing both the handrails and swinging both feet off the ground, and then fell as a result of this. So although the act of going down the stairs was done in an unconventional and unauthorized manner, it was something that this applicant needed to do in order to be able to perform the job duties, was go up and down the stairs. And the act of going down the stairs, even though it was done in an unconventional manner, was not seen as a substantial deviation from the applicant's duties. So it wasn't seen as horseplay. And even if evidence proves that the injury occurred as a result of horseplay, the injury still might be compensable if one of two exceptions is demonstrated. One is that the injured employee was a non-participant in the horseplay. So the example that James provided with the employees throwing the hard rolls at each other, if somebody was like hit in the crossfire, although it was as a result of horseplay, because that injured worker was not participating, their claim wouldn't be barred. Or if the employer, again, condoned or encouraged the activity. This may be found if the employer even had constructive knowledge that this type of behavior was customary amongst the employees and they didn't voice an objection to it. There are times when an applicant may live on the employer's premises, and there will be injuries that could happen that would be reasonable, and with living on a premise that wouldn't necessarily be reasonable with your job duties. So this is called the bunkhouse rule. So if you're making reasonable use of the premises and you get injured, it wouldn't be barred.
All right, so we're going to go now to the going and coming rule. And Ali, I do see that we're at the 43-minute mark. So, and we've got quite a few left. So we're going to speed through it a little bit more because it's very much important that people, that they spot the defenses early on so that they can issue their decisions. They can go to their attorney and say, hey, do I have a strong defense here? These are the issues. You got to gather the facts. And so by making sure we at least hit these without maybe going into detail into all these defenses, the adjuster can and the attorney can spot the issue, and that's really the most important part because your attorney can figure out how strong your defense is. So
okay,
let's hit the going and coming rule and take it away, Ali.
Sure. Okay, so injuries sustained during your commute to and from work are not compensable unless you were doing something that was benefiting your employer. If they asked you to make a stop on the way and you got injured, that would not be the going and coming rule. Or if the employer provided you with your car to get to and from work, or if you were a work from home employee, or if your job required you to travel from one place to another, none of these would apply with the going and coming rule. So just if you see somebody getting injured on their way to and from work, just know that that will be the going and coming rule and that there are exceptions that apply.
Yeah. Yep, that's just it, is if they are in a vehicle when the accident happens and they're not someone who drives vehicles for a living, there's a good chance you are going to have to deal with the going and coming rule. It's very common in farm labor where workers have to go from one field to the next. And so there's law that says a vehicle is needed because you can't go from one field to the next during the day if you don't have transportation, and therefore there's a benefit to the employer, and therefore the going and coming rule is accepted and does not bar the claim. So here's a few questions to consider. You guys have this in the slides, which are made available to you by Diane. And then next is the independent contractor defense, essentially whether someone is an employee versus an independent contractor. And of course, that assumes that the person is the person that worked for the insured. So you always have that issue first before you even deal with independent contractor. So, but go ahead, Ali.
This is just one of these situations where there's several factors. There's the Borello test, which has basically they're trying to see, did the employer control the employees or the independent contractors way that they had to perform their job duties? Did they provide them with tools? Did they tell them where they had to do the job, when they had to do the job? So the more independence the employee or independent contractor had, the more likely that they are to be seen an independent contractor. And the more restrictions provided by the employer, the less likely they're an independent contractor.
Yeah, and the thing is for this, the issue spot will be the employer is going to say, hey, he was an independent contractor. That's usually
Right.
how it comes up. And so, obviously you got to get the information from the employer, otherwise you're going to miss these defenses. It's always get the information. And
yeah, and it's not sufficient for the employer to just designate them as an independent contractor.
No.
It's a lot of times the employers may misdesignate them as an independent contractor when they're actually an employee. So this is something that you have to analyze yourself.
Yeah, they can be 1099 and all of that, but it doesn't mean they're going to be found to be an employee. They can also, or an independent contractor, they can even have an agreement that they're an independent contractor and it's not binding. So they're going to look at all the facts, and that's really, it's a pretty in-depth analysis. It's not something you're necessarily going to have all the information in the first 90. You just got to spot the issue. And actually, the whether someone's an employee is typically not impacted by the presumption of compensability because employment is not injury. All right, unreasonable refusal of treatment.
So if you have an admitted injury, or if your injury was adjudicated industrial and the defendant tenders medical treatment and the applicant refuses the medical treatment and this causes an injury or death, the injury or death can be barred if it's found that the employee's refusal to accept the medical care was unreasonable. The employer has the burden to show that they made the offer for the treatment and the applicant refused the treatment, and the treatment itself, the risks involved were outweighed by the benefit of the treatment, and a medical professional would have to say that had the applicant got the treatment, it would have reduced the applicant's disability or stopped the applicant from dying. An example was an applicant who refused a blood transfusion due to religious beliefs, and the refusal caused the death of the applicant. The test for reasonableness is not entirely objective. It may consider the applicant's subjective beliefs, but in this case, because the applicant chose to, follow his or her religious beliefs, it wasn't found that the employer should be liable for the death, because if they had accepted the treatment, they would have been alive.
All right, so next we're going to talk about some psych defenses. These are defenses that are laid out in Labor Code section 3208.3. The first is the prerequisites, and essentially for any psych claim to be made, there must be an actual event of employment. It could be, basically the way I look at it is, does it seem reasonably tied to work? That's kind of how I look at it. If there's an event of employment that is clearly tied to work, that's going to be met. But even if you have a work-related event or events, it could be multiple things. The applicant has to show that it's predominantly caused 51% or more by a work-related factor, and that just means that you take all of this psych disability, you take all the potential causes, and if 51% of them are work-related or more, then they've satisfied that prong. And then lastly, it's got to be an actual diagnosable disorder. It could be, depressive disorder, various other disorders that are accepted medical standards. And so that's the test. That's how you make a psych claim. That's how an applicant makes a psych claim. There is an exception to that 51% or more, and that's the violent act exception. And it could be, I gave you a few examples of rape, bombing, shooting. You know, it could be a big fight. There's lots of things that are considered violent acts. And if that happens, if there is a violent act or direct exposure to one, then all that has to be shown is that it's 35 to 40% of all the contributing causes. So it's a lower threshold, which makes sense because a violent act is much more likely to cause a psych injury. So that's where the exception comes into play. So let's say you've established the 51%, the applicant has, there's a potentially valid psych claim. That doesn't mean you don't have defenses. The first defense is going to be the 6-month employment rule, and that is you can't make a psych claim if you haven't been employed for at least 6 months. So anytime you have a psych claim, one of the first things you should do is say, well, what's the date of hire and what's the last day worked? Now, one of the caveats to this is it doesn't have to be continuous. So it could be someone who worked for 6 months, took a few months off, worked for 4 months, took a few months off, then worked for two months. Now they got their 6. Or it could be someone who worked for 2 months, had the injury, and then had some sort of an injury that was alleging psych, and then worked 4 months after that injury. Now their psych is gonna be okay because they just have to have that 6 months. Now, is it if there's been a severance, you know, from many years ago, and they come back, whether you count that, that's up in the air. But just know that it doesn't have to be continuous, and it can even be after the injury. There is an exception to it, and that's the sudden and extraordinary event exception. This is actually a very big defense, by the way. This is very, very common. We see this a lot. And so the sudden and extraordinary event exception is not what people think it is. People think sudden's obvious. Sudden, you have a specific trauma, something happens, it's sudden. It happens without notice, and you just kind of know when it's sudden. It's the easiest thing to prove. It's almost never an issue. It's the extraordinary element that is an issue a lot. And what I've commonly seen made by applicant attorneys is that the injuries to the applicant are very significant, and therefore the injury, the psych claim is compensable because it's an extraordinary injury. But that's not the standard. Extraordinary goes to how the injury occurred, not the severity of the injury. And so if it's an injury that occurred doing something that such an injury is potentially expected, you know, like a farm laborer falling off of a ladder while picking a tree, that's not extraordinary. That can happen. So since it's not an extraordinary mechanism of trauma, then the applicant would not be able to satisfy the extraordinary exception. So it's a very common defense. It's an important defense, and you need to look at it every time there's a psych claim. It goes straight to, is there 6 months of employment? The next is the post-termination injury defense. Now, we covered that earlier when it comes to the physical injuries. Well, Labor Code Section 3600A10 does not reference CT claims as being under that code section. In fact, it's specifically not included. The post-termination injury defense for psych claims is found in 3208.3, and it's essentially the same thing, except for it does include another exception of sudden and extraordinary event, which makes sense because if you've got, you know, something that is unusual for the job, it's more likely to cause a psych injury. And then another exception they have is that there's a finding of sexual or racial harassment by a tribunal, whether it be administrative or a court, whatever. And then the same defenses, or the same thing applies as in 3600A10, where medical records exist or knowledge by the employer, things of that nature. And then lastly, the date of injury is after notice of termination and before the actual termination. So you give notice of the termination, but the injury happens 2 weeks later, then that's going to be an accepted. But one of the most notable things here is that the code doesn't make exception for CTs with the date of injury after termination. So 3600A10 for physical injuries has that exception for CTs, which, as I mentioned earlier, makes it very hard, but they don't have that same exception when it comes to psych claims. And I think it's probably because if you're talking about a mental injury and you're saying that this mental injury is caused by ABC, you should have full knowledge that that's what's causing the injury. It's not like a physical injury where I mentioned earlier, you're not a doctor to diagnose cancer, or whether an orthopedic injury is work-related, things of that nature. It's just a very different beast. So if we see a psych or a claim that alleges physical injuries as well as psych, we'll raise both 3600A10 and 3208.3E. The next defense is good faith personnel action. And I'm going to just blow through these next ones because we are getting late and I don't want to keep people late. But the good faith personnel action is a bar when the injury was substantially caused by a lawful non-discriminatory good faith personnel action. And so it's intended to allow employers to do firing, to do reviews, suspensions, things of that nature, without having to then face a work comp claim. And so you're going to have to spot that issue if the claim is filed after some sort of disciplinary action, et cetera, and they're alleging psych, you're going to be raising this defense. This here is the standard. The elements that roll the case is what we follow when we do the evaluation of the good faith personnel injury defense or personnel action defense, and it's got the 5 standards there. You'll see that you just have to show that the personnel action was 35 to 40% cause of all sources. So it's a lower standard than the 51%. But this is the reverse, because we're trying to show that there's injury related to the personnel action as opposed to some other mechanism. So that's that. You got those elements there for you. If you need to look it up, you get a copy of this. Next, we're going to touch the statute of limitations. There's more than this. For example, S&W is 1 year from the date of injury. Unless it's the defense, then the defense has 1 year, but it's extended if the applicant filed a timely petition. So there's things like that, but we're going to just touch these main ones. The first thing I want to say is that if you don't raise the statute of limitations defense, it's bye-bye, it's waived. So you got to raise it. The 1 year statute of limitations. This is the most common. Someone has the alleged injury. You have to determine when they had to file. So if it's going to be the longest of those 3. So for example, if the date of injury is 1/1/22, they would have till 1/1/23 to file the claim under that first standard. However, if benefits were paid, it tolls it. And that's where these next 2 standards come in. Now, there is also estoppel available to the applicant to prove if they can show that the employer prevented the applicant from raising the defense based on improper behavior. Maybe they didn't tell the applicant of their rights, or they didn't provide the claim form, or they said you don't even need to do anything. You're all set. And so the applicant relies on that and shows that happened. The employer could be stopped from raising the statute of limitations. And of course, you want to get that claim form provided to the applicant anytime there's some possible injury, because that starts the statute. The next statute is the 5-year statute. So this statute only applies to the new and further disability. So if you've got a disability and they didn't timely file under the 1-year statute, but there was treatment provided, there was benefits provided, they can still come back and say, well, now there's disability and additional disability, and even though I didn't file a timely claim for the 1 year, I'm filing it for the 5-year. And so you would argue, well, you don't get any of the disability that was already existing, so what's new and what's further? So that's that's where that's going to come in. Estoppel still comes into play. You definitely, we don't see that very often though. Employers aren't trying to hide the ball. The employers are going to be upfront and move it. They want to protect it. And then the TPAs oftentimes will also fix any errors that an employer made. The death benefit statute of limitations. The key thing to take from this is that proceedings may not be commenced more than 240 weeks after the injury. So even if the death is work-related, but it's 245 weeks after the injury, it's barred. And then you'll see A, B, and C have the others dates that you can do, and it's any of those three. You have to evaluate your facts. Latches is something that I'll raise every now and then, and I basically go by whether I think there's been just an unreasonable delay. And if I see something come across my desk, a case, and it's been going for 5 years, and they're just now bringing in my client, and they could have brought in my client 5 years ago, and now we're being brought in to litigate something. We don't have witnesses anymore. We don't have the ability to do the proper investigation. It's just, I raise the latches. It's a legitimate defense that is not raised very often. I don't think a lot of people even know that it exists, but it does. And there's case law where it's been used in workers' compensation. The presumption of compensability is a big one. This one is, frankly, you could do a whole seminar just on this. It's so important. So as I said earlier, I'm not going to go too detailed into this because we're going to end this, but always, when you get notice of a case, do your investigation right away, get your notice. If you're denying it, get your notice out within 90 days of that claim form being provided. And it's the claim form that matters. It's not an application being filed. It's not notice to the employer. It's when was the claim form provided, turned in by the applicant. That starts your 90 days. You can, if you don't timely deny within that 90-day period, you can be barred from using a lot of your evidence. Don't think that just because you're not within the 90 days, you can't deny a claim. Sometimes evidence comes out. I've had evidence, some crazy ones where it's come out after the fact, and we were able to do a subsequent denial based on the evidence that couldn't have been discovered with reasonable diligence within the 90-day period, and that's really the goal. So just make sure you do a timely investigation, get your notice out. The notice actually doesn't even have to go out to protect you. What matters is when did you deny it? So that may just be in your claim notes, but still send out the notice to the applicant. Don't be relying on the Rodriguez case, which says it doesn't have to be in writing conveyed to the applicant. Just get it out and do it right, and make sure that it's your denial is very clear, unconditional, and that your defenses, whatever defenses you have, you just list them in there, even though that's not even required. You get them in there. And then the last thing I'm going to say with the presumption of compensability is if the date of injury is 1/1/2022, I'm going to calculate my decision date 90 days from that, even if I don't have a DWC-1. And the reason for that is I just never know if the employer got one, and sometimes they didn't tell me. And by doing this, I'll never have to litigate the issue because the decision was made within 90 days. Now, that's not always going to be possible, but anytime it's possible, that's what I do because I just don't want to have to deal with this issue. The presumption doesn't apply to things like whether applicant is an employee, the 6-month rule, good faith personnel action, and the statute of limitations. So there are defenses, there's probably other ones too. Those are the ones that I can think of. So don't assume just because you missed your 90 days, you can't deny the claim. And don't assume that it's an issue that is even subject to the presumption of compensability. And that does it. I think we went a teeny bit over, but I think we got it done.
I think you did. That was a lot of information, gentlemen. You did an excellent job. But before we go, Patrick Humphreys has got a question, and he's asking, does the 5402 90-day decision apply to the issue of employment or to coverage?
The issue of employment, there is case law that it does not apply, as I just pointed out on that last slide. I think your question probably was received just before that. And then as for coverage, I do recall seeing case law saying that coverage is not, and it makes sense. It's not injury. So I don't believe coverage is subject to the presumption of compensability either. Obviously, I'd want to gather the law. It's been a while since I saw that, but I don't see any reason why it would apply. And I definitely saw law that it does not.
Okay. Well, gentlemen, I want to thank you very much for being part of the MacroPro and Friends webinar. We want to thank all of our attendees. We see a lot of names that we recognize. And just as a reminder, MacroPro is a document retrieval company. We can get records for you not only in California, we can get records for you nationwide. In fact, we can get them for you worldwide. So if you have a litigated case, or if you have an authorization form that you want us to utilize, we can do that. Until the next time, we will see you later. Bye-bye now. Thank you again.
Bye, guys.
Bye.